And I want to welcome everyone to the League of American Bicyclists Club Leadership Webinar for March of 2012. I am Scott Williams. I'm the Membership Director at the League of American Bicyclists, and tonight we'll be talking about risk management and liability for your organization. Our first presenter tonight is Gary Bruston, who I know because he has been a board member for the League of American Bicyclists as long as I have been at the League. I understand he's been an avid cyclist for over 45 years, starting with a Schwinn Varsity 8-speed. He's got better gear since then, still rides at least 3 times a week, and he loves doing long climbs in the hills. He graduated from the University of Southern California in 1971 and earned his law degree at Hastings College of the Law in 1975. He is a member of the California State Bar Association. And his passion for cycling has also shaped his professional career. And 20 years ago, he decided to transform his law practice from general personal injury cases to specializing in cycling practice. And that's all he does now as a lawyer, and has handled over 1,000 bicycle cases. Really glad you're there for us, Gary, although I'm sorry that there's such a demand for it. He maintains offices in Northern and Southern California and works with other attorneys across the country on selected liability matters. He's a mediator specializing in cycling disputes. His office co-sponsors events and teams, and he acts as a volunteer attorney for various racing clubs. And as I mentioned, he is a board member for the League of American Bicyclists and the Silicon Valley Bicycle Coalition. And he served on the board of directors for the California Bicycle Coalition for 10 years. And every March he comes to Washington for the National Bike Summit, which is coming up in 2 weeks. 2 weeks from today, that starts in D.C., and there's still time to register if you want to come but haven't registered yet. And he will tell you more about how to get in touch with him later. We also have with us Marla Peters, who is the Senior Vice President for Special Programs at American Specialty, who is the broker that provides the insurance coverage for the league clubs, and many of you are insured by American Specialty. And Marla has been working with the league for 17 years in what I think has been a great relationship for both sides. So without any further ado, I would like to turn things over to you. Gary, take it away.
Thank you, Scott, and welcome everybody to my presentation on risk management, better known as what a way to ruin a perfectly good Tuesday evening. I mean, we're going to be talking about lawyers, claims, lawsuits, liabilities. I can assure you about 10 minutes into my talk, you're going to be wondering why in the world you ever decided to plan an event. But please keep in mind, stay with me, this is a 2-part talk. We're going to be talking about avoiding risks and where they might be. And secondly, we're going to be talking about how to manage those risks, not just through prevention, but also through insurance. But before we get started, I want to manage one of my own risks, and I'm going to start with a legal disclaimer, so here we go. I will be talking about general legal principles pursuant to California law because I'm only licensed to practice law in California. If you are residents of other jurisdictions, you should always seek the advice of local counsel because laws vary from state to state. All right, now we can go forward. So let's talk about our topics tonight, and we're going to go through them briefly here. We're going to start with the anatomy of a lawsuit. I'm going to explain to you what a lawsuit is so you get that behind you and you don't have to worry about it too much. Then we're going to talk about negligence law in 3 easy steps. That's the theory upon which someone is probably going to file a claim. Then we're going to talk about common pitfalls. Where do the claims come from? Where do I get calls all the time from folks about, well, I was on a ride and so-and-so didn't do this and didn't do that. Then we're going to talk about releases and waivers of liability. Those are very powerful legal tools, and I'm going to encourage everybody to use those in your events. We'll talk about insurance coverage. I'm just going to go through that very briefly because Marla is far more qualified to talk about that than I am. We'll talk about reacting to claims. What if somebody files a claim or a lawsuit against you? What should you do? What shouldn't you do? And we'll try to keep it as simple as possible. And of course, questions and answers, and I think Scott mentioned this earlier. Feel free to ask a question during my talk. We don't have to wait till the end. I'd prefer that this be interactive as much as possible. I normally give this presentation in front of a live audience, and there's a lot of questions, and it makes, I think, things a little more interesting. So let's dig in here. Let's start with the anatomy of a lawsuit. There are basically three parts of a lawsuit. There are the plaintiffs, and those are the people that are filing the case or starting the complaint. Then there are the defendants, and those are the people that are getting sued. And then, of course, there are the reasons to sue. And in California, at least, I think generally across the country, the reasons to sue are pretty simple in the civil law. They're looking for money, and we'll talk about the categories in just a moment. But let's go back to the plaintiffs. Who is going to be the plaintiff, or who is going to be the person that's going to be starting this lawsuit? It is almost always going to be a participant in the ride. However, there can be others. I typically call them party crashers or pirates. These are people that jump onto the ride. They don't register, they don't sign waivers, but believe it or not, in some jurisdictions, they can actually go forward with a case against you. There can be a spectator. That is somebody who certainly is not a participant, but is just around the ride and gets injured as a result of one of the common pitfalls we're going to talk about. It could be one of your employees, it could be a volunteer, it could be a sponsor or any other organizer of the event. So there can be lots of plaintiffs. Let's move down to the defendants. Who is going to be the target defendant in a lawsuit? If you were all sitting in front of me, I'd say everybody raise your hand, because unfortunately you're going to be the first one to be named in a claim or a lawsuit. In addition to you, it could be your organization, your business, your corporation, your employees, your volunteers, your sponsors, or any other person who had anything to do with the event. So I can tell right now, even though it's very silent, I can tell that all of you are getting ready to jump off the line because we're not quite 10 minutes into this, and you're thinking, oh man, we've got lots of plaintiffs, lots of defendants, and now comes the real kicker. Why are they suing? They are suing for money damages, and in essence, those are 7 different categories. The first one would be their medical bills from the date of their accident all the way up to a settlement or a court verdict. The second one would be for future medical expenses, and those would be for expenses, for example, if somebody severely injured their knee, let's say, and they had to have a knee replacement. Let's say they're about 30 years old. Well, knee replacements only last for about 15 years, so they're going to have to come back another 15 years and another 15 years and keep coming back. But you cannot leave these cases open forever, so you have to calculate the future damages into the present settlement. So the first 2 elements of damage are past and future medical bills. The next 2 would be past and future loss of earnings, and it's the basic same concept as the medical bills. The next 2 would be past and future loss of enjoyment of daily activities or pain and suffering. And the last one is property damage. And I really encourage you to speak to a very experienced insurance person about these limits of liability on property damage. I don't know if you've been reading the magazines and going to the bike shops. There are Colnago bicycles out there that exceed $15,000. It is just astounding to me. As for myself, I won't pay a penny over $8,000 for a bicycle. That's where I draw the line. But things are getting more expensive, so you'll need adequate coverage for these types of categories. So that is the lawsuit. Now, what does a lawsuit look like? It is actually in California a 4-page form. And you check off a bunch of boxes, maybe a dozen boxes. You take it down to the Superior Court. You give the clerk $395, and you are the proud owner of a Superior Court lawsuit for negligence. Which brings us to the law of negligence. 3 things. I'm going to really oversimplify it. My law professors back at Hastings would be turning over in their graves right about now, but I'm really going to simplify this as much as I can. First step, negligence is failure to use ordinary care. Or, I like to say it another way, being less careful than another ride event director in the same situation. Or in a word, carelessness. But let's go back to the word ordinary. It's failure to use ordinary care. That doesn't mean you have to be perfect. Doesn't mean you have to cover absolutely 100% of everything. You just have to be careful, not careless. Here's an example. Let's say you're putting on a Century ride, and about 24 hours before the ride, you're doing your final course evaluation. You're going through the course and making sure all the hazards are marked, or you're aware of them so you can mark them. And let's say you're driving along, you got a little bored, and you kind of look down at your smartphone. And you look down there maybe for 3 or 4 seconds, and you look back up. During those 3 or 4 seconds, you may have missed seeing a very obscure pothole that maybe the bike riders on your event are not going to see. Well, that would be less careful than another ride event director in the same situation. So it doesn't mean that again, you don't have to be perfect, but remember, you're going to be compared in the law of negligence to somebody who does the same thing under the same circumstances. You just have to be as careful as they are. Number 2, in negligence, you need injuries and expenses. And we just talked about those, the 7 elements of damages and expenses. And number 3, you need a bridge between the carelessness and the injuries and the expenses, and that would be causation. So really in 3 easy steps, negligence is carelessness causes injuries and expenses. It is just that easy. It's not a multinational antitrust action where the U.S. attorney is going to get involved and we're going to litigate this case for 10 years. It's pretty simple stuff. And the reason I'm telling you it's simple is because the easier it is to file a lawsuit, the easier the theory of filing the lawsuit, the riskier these situations become for you. So let's move on to common pitfalls so you can avoid most of these situations. Without a doubt, the number one, at least in my office, the number one call that I get from a potential client, and let me just go back for a second. I don't take on these people that call me about rides and race negligence and lawsuits and claims. I simply will not do it out of choice. I know way too many people in the bike community, and I simply won't take these cases on. But having said that, I do get the calls, so I have collected some statistics. So the first one is failure to inspect the route for dangers. And usually it's going to be a pothole. It's going to be a lip in the road. Even open dangers can be daunting for ride directors. When I give this talk every year up in Northern California to a group of ride directors, they always come up with, well, what about a cattle grate? I don't know if any of you have your rides going through areas where there are cattle. You remember those big cattle grates in the road that have the bars going across them, and they always seem so confused as to what to do about that. So I asked them, what do you do? And some ride directors say, look, we don't do anything. We just, let the normal county road sign warn people about it. We consider it open and obvious, and just let folks, negotiate it as best they can. I have other ride directors say, well, we put up a lot of signs and we spray paint the roadway, caution, look out for this. And I had one ride director, though, who was he just wanted to do everything he could to make it safe. And here's where he went way overboard, I think. He put down a giant piece of carpeting over this cattle grate. Now, you gotta envision this. I said to him, how did that work out for you? Because I've got to believe as the bike riders went over this carpeting, although it must have been a smoother ride, there's always the hazard that a lip of that carpeting will fly up and get into somebody's fork and upend them. The other hazard is that if a motor vehicle goes across that carpeting, it could fly up and hit a bicyclist behind them. It could fly up and hit a car behind them and block the windshield. And then there's the really big hazard with putting carpeting on these cattle grates, and it's the cattle. Can you imagine all the roaming cattle around on the road? I mean, it's a bike ride director's nightmare. So you don't have to go over and above the call of duty here. You simply just have to act reasonably. I think if you want an answer about what to do with a cattle grate crossing, just leave it there. Maybe on your route slip, just mention it as one of the hazards. You don't have to put wall-to-wall carpeting on it. That's the bottom line. The next one, marking the route, or perhaps mismarking the route. A lot of folks like to put up signs about you have a turn coming up over here, or they paint wording on the roadway. I want you all to keep in mind that only one group of people or one organization can either alter a road or put signs on a road, and that is the governmental entity that controls the road. So if you're going to market, I suggest you certainly get a permit. If you're going to do these rides, you should have a permit from the governments or the jurisdictions you're going to go through, and have them assist you in putting the markings up. Because invariably, I get a call almost every year from a rider who said, I'm on a Century ride, I'm going downhill, I know there's a turn coming up, I'm not quite sure where it is, and all of a sudden, right at the intersection, there's a sign, turn right. And of course, he tries to make the quick right turn, and he's going way too fast, and he goes flying off the road, and he files the claim. In fact, 3 or 4 months ago when I was up in Northern California giving this presentation, some of the ride directors came up to me and said, you know, we've got a claim just like that pending. I said, yeah, I know, it's unfortunate. So what you want to do is work with your local governments to make sure that if you're putting signs up, they are placed reasonably and carefully. And here we're going to talk about a new emerging theme in this talk, and that is, don't assume a responsibility or a skill set for which you have no qualifications. I mean, really, none of us really know how to put signs on a road adequately. I mean, there are engineers that get master's degree in this to make sure that everything is lined up properly and there are proper warnings. So please delegate this to somebody. It's better for your participants, it's better for your ride, and now you are shifting risk to somebody else. Lawyers love to do this. I'm not being crafty, I'm not trying to be cagey. I'm trying to teach you to make sure that whatever you do it as carefully as possible and with people who are most qualified. All right, the next one, maintaining a closed course. I don't know if any of you do that. I know I do get calls occasionally from triathlons saying, you know, we had these intersections closed off, and invariably a rider goes through it at 35 miles an hour, and somehow the car gets onto the course in the intersection, even with police directing traffic at the intersection, and there's an accident. Closed courses are a really high standard of care. If you say you're going to do it, yes, you've got to be careful, not careless. You've got to use ordinary care, but the bar is now very, very high. So I would say if there's any way to get around not saying you have a closed course or not guaranteeing a closed course, I would certainly take that route instead. Let's move on to intersection control. We kind of touched on it briefly. I have a lot of rides that I talk to, a lot of ride directors, and they say, you know, we've got to, we can't change the route. We've got to cross a busy highway here. And in California, we have a lot of those high-speed roads, and they're in the back country where all the Centuries want to be. And they say, you know, what do you think we should do? I said, well, first you really have to get a permit and then ask what the government wants you to do. And almost always the government is going to want you to have police officers there. Again, you don't want to call the local Boy Scout troop to direct traffic on Highway 101 in California. If you're going to do intersection control, make sure that you have police officers doing it, because once again, the only people, at least in California, who have the authority to direct traffic are police officers. And once again, they're the experts. So you want to shift the risk, or a substantial portion of the risk, over to them. But again, most importantly, you want to protect your riders and make sure you have a good ride. Let's move on to crowd control. Remember we talked about the plaintiffs in a lawsuit, and one of them was a spectator. Well, the spectator is going to get injured generally at the start line or at the finish line. And that spectator will almost invariably blame you for not having crowd control. Now, we all know about the finish lines on crits or criterium races. We know the finish lines of the Tour de France. There's just immense crowd control. Even with that, they have problems. But if you know there's going to be a mix of spectators and riders, you really have a duty, as we say under the law, to try to do something to protect the spectators. So if you're in that situation, do the best you can with it. If you're not quite sure how to do crowd control, you might want to consult with a local government planning department or even a police department. Get some guidelines from them. Next thing, employees and volunteers. I know that if you're putting on a big event, you're going to have volunteers, you're going to have a few employees. Please pick and choose them carefully. And don't assign them a task for which they don't have the skill set again. Because if an employee or a volunteer is negligent in any way, that negligence instantly connects right back up to you. It is just transmitted to you instantly under what we call agency liability. So be sure you know these people for the most part. Make sure they are qualified. Again, it's okay to have high school students do certain things, but don't assign them tasks which are clearly over their qualifications. Next one, bike safety checks. Hang on just a second here. I thought there was a question coming up. I guess not, Scott. Not a problem. Let's go to bike safety checks.
Gary, I do have a number of questions if you want to break for questions now or finish out the slide.
I'll tell you what, I'll finish. You know what, why don't you go ahead and just throw them at me at this point, because all I'm doing is rattling on, and I'd much rather have a question so we can keep it interactive. Go ahead.
Okay, in terms of your first point on inspecting the route, we had a question about surveying the course prior to the event. Why would that be a standard of care is the question. What if you don't and accept the road as it is? Our courses have a couple thousand potholes. How can they be expected to deal with all those potholes, be responsible for all those potholes?
Well, I think my example of a pothole wasn't exactly perfect. I think that you certainly should inspect the course. And any bicycle ride director that I've talked to, they inspect it about 3 times before the event, and their last inspection is 24 hours before the event. They want to know if there's any construction being done. They want to know if perhaps there is a pothole there. Maybe that pothole will not be noticed by a bike rider. Maybe it's filled with water. Who knows? Maybe it rained or it's going to rain. You just have to go out there and be alert to things that you think might be hazardous to you if you were riding on the road. I think as a bike ride director, if you're putting on a ride, you have a duty to do that. Don't worry about every single pothole. Folks have to obey the rules of the road. They have to assume a certain amount of risk. We're going to talk about liabilities and releases and assumption of risk here in a minute. But just try to be aware of things that maybe will catch riders by surprise or place them in a somewhat of a trap situation.
And in terms of course inspection and sort of maintaining the course, does any of this apply differently? Is there anything you would add in regards to off-road courses?
That's a very good question, and I'm a little reluctant to address that one because all the bike ride directors I have spoken to and have done research for have been road events. I believe if you feel that the course in an off-road event may have potentially unreasonable hazards, you may want to get a second opinion from another ride director. There are cases that come up in the ski field where people are out skiing and they go over a mogul, and the mogul was just so radical that nobody would have ever expected that. And because it was so out of line with what the norm was, it was an actionable type of case. So I think that look for things, once again, that will trap or surprise riders and cause injuries. That's perhaps the best answer I can give at this point.
Okay, I guess in a similar vein, someone's talking about bystanders. You've got 100 miles of road on a Century ride, 100 miles of road where somebody could just walk onto the course and be hit and injured, and both the rider and the person who were hit and injured may hold you responsible for that. What is your responsibility in terms of controlling the course?
Well, one of the things in negligence law is that the risk must be what we call foreseeable. I didn't go into that detail, but I will now. It has to be a foreseeable risk. So if you have a Century ride and it's out in the countryside, and somehow a pedestrian is crossing a road to get to a general store and there's an accident, well, that isn't really a foreseeable risk that you have to worry about. However, let's say you're putting on a race, or you have a century ride, and folks for some reason are just getting jammed up at the finish line, or they're jammed up at the start of the event. And there are spectators milling around, and there are spectators crossing the roadway. Now it's foreseeable that there's going to be a problem. And when that happens, you have a foreseeable risk, and you must take steps to, in some way, carefully prevent that risk. So again, you don't have to worry about the full 100 miles. You just have to worry about, I guess you might call it choke points, where traffic will jam up.
Okay. If I put up signs warning about one rough surface or one cattle grate, am I responsible for putting up a sign for every cattle grate and every rough surface?
I think that I'm going to change this a little bit. You are responsible for warning riders of, once again, foreseeable risks or problems that may surprise them. A cattle grate is pretty open and obvious. Again, we talked about potholes that may be hidden. I think that you have to use good common sense here. But if you are going to start marking these risks, you should do your best to mark most of them, because people will become acclimated to the fact that you are marking them. So again, try to be consistent. That doesn't mean you have to put bright orange or bright green spray paint around every pothole. It just means you want to act as reasonably as possible. And please, I wish I could say to you, if you do this, 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 and this, you are negligence-free. It never happens that way. Once again, you just have to use your good common sense and judgment and do your best, and to be as careful as you can to prevent injuries that may not be noticeable to the riders as they come down the road.
Okay, we have someone that takes a little bit of issue with the word ordinary in terms of the standards. It seems pretty vague, and I can definitely see where that's coming from. Is there any better way to kind of define this so people understand what the yardstick is?
Yeah, here's how it unfolds in a courtroom. I was hoping not to get into this, but I think it's a good education, so bear with me, okay? If somebody was going to file a claim for negligence against a ride director, what would happen in a courtroom is, eventually after the plaintiff, the participant, testified, the attorney would next put up an expert witness. That is somebody who would get up there with the qualifications to testify, and the qualifications would be another ride director, perhaps from another state, who would get up there and say, well, here's the standard of care. Here's the standard of ordinary and reasonable care in bike rides. And here's what I've been doing for the last 15 years. And in this situation, I would have done X, Y, and Z. Unfortunately, the defendant only did X and Z, and therefore I believe he fell below the standard of ordinary care. So that's how it unfolds. There will be an expert testifying against you. Of course, your attorney will hire another expert, and that expert will say, well, I've put on 20 years of events, and I can tell you that what this ride director did was absolutely up to the standard of care. And then a jury is going to have to weigh both of those opinions, and a jury will then decide whether or not you met the standard of ordinary care or you didn't. It really is a loose standard. That's the problem. It's not black and white. It is like this great big measuring stick that kind of floats back and forth. So that's the problem with negligence law. It's rather fluid. I'm sorry, I wish I could say, once again, if you do X, Y, and Z, you're going to be fine. I can't. It's going to be specific to a set of facts. It will be specific to expert testimony, and it will also sometimes vary on the makeup of the jurors who are hearing the case. I guess everybody has a really bad ulcer right about now. Scott, you want me to move on?
I'm sorry. See, now I'm the one with the mute button on. I have a couple of more questions pertaining to sort of road hazard type things,
Sure.
and then we'll move on. I've got some more questions, bigger questions that we will come back to. So, a question just about the responsibility, for instance, of the city or the state in their maintaining roads that you're using. If you're having a bike ride and city water pipe is frozen and burst and it's pouring frozen water and ice is up the road, is, in the case of an accident and a suit, are you responsible? Are you going to are they going to try to hold you responsible for that? Is the city responsible for that? Any comment on that?
Yes. In that situation, I'm assuming that the pipe broke, let's say, during the ride. I'll make that assumption. So again, it becomes fact specific. I think at that point, if a pipe breaks and all of a sudden riders are going down right after it breaks, well, certainly the city is going to share some responsibility for that. And I don't think the ride director is going to share responsibility, because the ride director has done everything he or she humanly could 24 hours before the ride. Unless the city said to them, well, we think this pipe's going to break tomorrow at 3 p.m. I don't think that's the situation. But that's another reason why what you'll find out if I know many of you probably have applied for permits for rides, and you will see in these permits that the governments will make sure that when you buy insurance, you name the governmental entity as an additional insured, so they will be protected from these risks also. But as a lawyer, if I did these types of claims, I would certainly be targeting the governmental entity because they're the ones that maybe failed to maintain that pipe, and they are the ones, at least in my target, would be primarily responsible. But like I said at the beginning of our talk, there can be lots of plaintiffs and there can be lots of defendants, and one of the category of defendants would be anybody else who might be responsible for any liability on the ride, and certainly a government with that kind of a pipe bursting, I think has exposure, absolutely.
Okay, and then I had another question about another road hazard that you haven't touched on yet, and that is other riders. How does liability play out in a situation when it is another rider who is acting, well, who is or is not acting safely, but causes others to crash with associated damages? What's the club liability situation?
Scott, in California, the liability is almost non-existent on a rider versus rider situation. In fact, there is specific case law on that in California. And it was a Century ride where one rider was riding next to another and overlapped the wheel, and one rider went down. And so, they come after the ride director and they come after the other rider. And the law in California is pretty clear. Co-participants or participants in a recreational activity assume the risks of injuries as a result of negligence. And because they assume those risks, they do not have a viable case. And in fact, their case could be thrown out of court midway through the litigation. That's California law. I hope that, and then that one, I'm very specific. I can be black and white. I can give you some great assurance on that one, at least in California. Outside of California, if you're using a release, and we're talking about that, most of the releases will also release the ride director from liability if co-participants are injured.
Okay, I think at this point it makes sense to move forward. We have some questions about releases that we'll talk about later if you don't get to it, or if you do, and a few other sort of big questions about liability for boards in cases of this matter. But we'll get to that later. If those of you who have asked those questions can wait, we'll definitely get to it, and I'll let you continue with your presentation, Gary.
Okay, Scott, thank you. So let's talk about bike safety checks. I really don't recommend you do that. I think it's a great idea. I think it's wonderful. I think it's a good deed, but it really is a risky situation. And if you do intend to do it, remember, you're not an expert at safety checking a bicycle. You are the ride director. You are to you are the person to be directing others. You should consider yourself up in a helicopter, so to speak, above the event, telling people what to do. So who is qualified to do a bike safety check? I think a bicycle shop is. And bike shops love coming out to these events, and they got their van or their trailer there, and they're getting great public relations, and they know what they're doing. And again, you are choosing somebody. You are being careful. You're using ordinary care, and you are choosing somebody who is highly qualified to take care of this task. So please, if you're going to do bike safety checks, try to get a bike shop to do it. Same with equipment repairs. I must tell you, and I'm sure most of you who work on your own bikes know this, every time you adjust a bolt or a screw on a bike, there's actually a torque requirement. For example, on a seat bolt, I mean, if you over-torque it, it will snap and the seat will fall off. If you under-torque it, the seat's going to fall off. If you get it just right, you're going to have a great ride. Bike shop mechanics know how to do this. They have torque wrenches. Now, I'm not saying you have to have anybody out there with a torque wrench. I'm just giving you an example that it really does take expertise to do some of the repairs on a bicycle. And as a bike ride director, you really don't have that expertise usually. So please delegate it to the bike shop, let them do it. Or what I like sometimes is if you come up on the course and you see somebody with a mechanical problem and you don't want to really get involved, give them the tools. Let them do it themselves if they feel qualified to repair their own bicycle. I'd prefer a bike shop to do it, but the next step down is let them do it themselves. Let's move on to fancy term adequate hydration. That is, people are just dying of thirst out there. And this is a problem that comes up, I'd say, every 2 years or so. I know when I first started doing bicycle law 20 years ago, one of the first calls I got was from a triathlon in the La Jolla area, which is in San Diego, California. And the promoter just miscalculated the amount of water or energy drinks that were necessary for the weather conditions. And people were getting terribly sick and dehydrated and overheated, and there were a lot of claims on it. And the event director finally got up and said, look, I'm sorry, I really made a mistake. And he was responsible for it. I think as recent as a couple years ago, there was a marathon, in, I think it was Chicago, and the weather really changed dramatically. And for those of you who have spent summers in Chicago, you know it can get very hot and very humid. And the event got so dangerous that they actually called off the event. So what do you do in this situation? Well, listen, most of us live in an area where we can predict the weather, or we can certainly get on the internet and figure it out pretty quickly. But if there is any question in your mind whether or not you have adequate food, water, energy drinks, whatever it might be, I suggest you consult with a sports nutritionist and get some expertise on this, because again, you're the director, you're not the expert. Find somebody who is, and if you can get something in writing from them, here comes the lawyer again, unfortunately, but I'm here to defend you. If you can get something in writing from that nutritionist saying, well, this is what you need under these circumstances, you put that in your file, and I think you've been more than careful. I think you've been extremely careful, and I think that you've done everything you can to protect yourself from negligence in that situation. Next one, rental bikes and helmets. Those are just like the bike safety checks. You're not in the rental bike business. You're not in the helmet business. Trust me, you don't want to be in that business. You want the bike rental company to come out there, if you're going to do this type of thing, and let them rent the bikes. Let them fit the bikes. Let them adjust the helmets. That is so important. You don't want to get involved in that. It's just not why you put on a bike ride. Next one, agency liability. We talked about employees and volunteers, and you want to make sure they're responsible, because anything they do will connect right back up to you in terms of liability automatically. Last point I want to make is first aid, and there seems to be some confusion about this. Let me give you a scenario. Let's say you're out driving around the course, and all of a sudden you see a rider go down, he hits that pothole that you missed that the previous day, and he falls, and he gets a terrible laceration in his arm. And I mean, he's really starting to bleed now. And you will stop and say to yourself, well, you're going to call 911. Everybody does. That's not the problem. You say, but wait a minute. If I go up there and help this guy, am I going to get sued? Because, I mean, I'm not a doctor and I'm not an expert at this, and I mean, I could be negligent and get sued for that. Well, in California, we encourage Good Samaritans in this particular situation. In California, you can render emergency first aid treatment to anybody who needs it. So let's say you jump out of the car, you grab a towel from the back seat, the towel is not sterile, you apply pressure on this poor guy's wound, you probably save his life, the paramedics get there, take him to the hospital, and lo and behold, he gets an infection from your towel. Well, I mean, is he going to turn around and sue you for the next 5 days he had to pay for the hospital stay? He can try to do that, but in California, you are going to be immune from prosecution. So if there's any doubt in your mind, at least once again in California, if you should render aid, just go do it. I mean, as long as you do it with good common sense, you will be protected. So those are the common pitfalls. Believe me, there are others. I didn't go through all of them, and I get educated every year when I give this talk. People say, well, here's a new one I got to claim on. So this is not entirely inclusive, but I think it hits most of the high points. So let's move on to our next topic. We're finally getting into some clear water here, and something to be happy about in terms of the legal situation for you. We're going to talk now about releases and waivers of liability. These are powerful legal weapons in your arsenal, and they are remarkable documents. Let me tell you what a release is. A release is a document where somebody signs it. It's a contract, and they say, I agree, because I'm participating in your event and I paid registration, I agree to release you and everybody else. I mean, almost every defendant we talked about earlier in the talk, they're releasing everybody from any kind of negligence, and they don't even know how negligent you're going to be, and they're still going to release you. They're releasing you from all injuries. They don't even know how injured they could possibly get, and incidentally, they're releasing you from a death claim also, which almost never happens, just so you know, but the releases can go that far. And they are releasing you from those 7 elements of expenses and damages before they even know what they're going to be. So this is a really powerful legal document. In California, 30 years ago or so, they were unenforceable, but now they are, and they are becoming more and more enforceable every time a new appellate court case comes down. But wait a minute, you're saying, well, you know, we've been going through this for, 30, 40 minutes and all these risks and everything. I mean, if a release protects me, why do I even need to worry about risks? And why do I need to pay for insurance? Well, unfortunately, for every general rule in the law, there are things called exceptions. And there are exceptions to the release rule. So I want to give these to you so you can hopefully be aware of them. And most importantly, and Marla, feel free to pipe up anytime you want, you can insure against these things that aren't covered by a release. Let's start with inconspicuous language. Years ago, people had this little fine print at the bottom of the registration form, and that was the release. That isn't going to fly. Or they put on the back of the form. That is not going to fly. A release should look like a release. It should have a title at the top, release of liability, waiver of liability. It should be in reasonably bold print. So when somebody reads it, they know exactly what they're reading. Number 2, spectators are an exception to the release because they didn't sign the release. They just came to the event to watch one of their relatives or a friend, or they were curious. So if you have spectators there, they are signing releases and you will not be protected. The next one, pirates or people who are on the course without paying the registration fee. Well, out here in California, they may have rights. However, a recent appellate court case came down that said even though they may have rights in this situation, there is that theory of assumption of the risk that we just talked about earlier, and that will block them from going forward. So even though they might have rights with or without a release, the assumption of the risk defense throws them out of court, at least here in California. Next one is reckless conduct. I'm going to bypass that one and go right down to intentional acts. And here we're going to make a distinction. We talked earlier about the law of negligence. That's the theory upon which most of these cases are going to be filed. However, there are other theories how they can be filed. And one of them is an intentional act. And you almost never see it, but let me tell you a story. Years ago, I knew a ride director up in Northern California, and he used to man his own rest stops, at least one of them. And, once in a while, a pirate or somebody who didn't register for the ride would come up and, try to get some of the food and some of the drinks, and he just thought that was terrible. And he said to this one guy, look, you can't do this. You didn't pay for the ride. It's unfair to everybody else. Now get out of here. And the rider just kept coming and, grabbed a banana or something, grabbed a bottle of water. And this ride director was from New Jersey. And I guess they do things a little differently in New Jersey than they do in Northern California. So he went around the table and he just shoved this guy right out of the rest stop. That is an intentional act. That is assault and battery. That will not be protected by a release because it's against public policy. And that you cannot even insure against. So although it probably would never happen, I want you to know, stranger things have happened in this world. The point I'm trying to make is releases only protect you against negligence, not against intentional acts, or our next category, something called strict liability. That sounds pretty ominous. Strict liability is generally the theory upon which somebody will sue you for product liability. And you're saying, well, I'm not a bike shop, and I'm not giving anybody a product. I mean, I hired a bike rental agency to take care of that. I hired the bike shop to do the repairs, and so why would I even have to worry about strict liability? Because you're handing out food. And if the food is contaminated, it is a product. And if it's a product and somebody gets sick, they can sue you for strict liability, and the release will not protect you from strict liability, but your insurance coverage will. So understand that even though I'm telling you that there are some really difficult, risky areas, insurance will generally cover you. Let's move down to the next category, minors. People under the age of 18 in California are a minor, and they cannot form a contract. They don't have the, quote, legal capacity to do so. So if somebody comes up to your table the morning of the event and they look under the age of 18, I suggest you ask them for some kind of identification. And if it really is obvious they're under the age of 18, you might not want to let them sign the release, and you might not want to let them into the event, because that release will be absolutely invalid. Let me go off on a side tangent here. I talked about having a table where people will come up and sign the release. I know a lot of you perhaps like to use electronic signatures. Let me talk to you briefly about that. I know that electronic signatures in some places can be enforceable. I do not recommend it when I speak to my ride directors in California. I say, listen, what you want is something called an original signature, or what I heard an insurance company once say is a wet signature. That means they got to sign it with a pen. Now, if I had to go to court and authenticate that release, I mean, even if the other person said, well, I didn't sign a release, I said, well, I think you did, because here's your signature, and I just hired a handwriting expert who's going to testify that it is your signature. In the electronic signature situation, it may not be as easy. In addition, you're actually able to look at people as they come up to the table. You're kind of like a bartender. Boy, this person looks under the age of 21. Maybe I better not serve them without asking for some ID. I think you're under a duty to get a look at everybody as they sign this release. And I think that a lot of insurance companies do require original signatured releases. And let me go one step further on this point. Every important document in the legal world has to have an original signature. I'll give you two examples. Number one, when you buy a house, all of us who have bought houses, boy, when you sign the deed, I got to tell you, it's an original signature. It's going to be notarized. If you write a will or a trust or anything that's going to control major assets, it has to be an original signature. So I believe a release, like I said earlier, is a very, very powerful legal tool and a very, very important legal document. And I encourage everybody to have some kind of system in place for original signatures. Let's move on to the next one, a lost release. And this actually happened to one of the bike ride directors I know in Southern California on a death case of all things. He couldn't find the release that the person signed. That can be a big problem. Some insurance companies will still defend you even though you've misplaced the release and you can't produce it. Others will sometimes limit their coverage, but I'll let Marla answer questions on that if you folks have those types of questions. So how long are you going to hold the release in safekeeping? Well, in California, we have a 2-year statute of limitations, which means they must file a lawsuit within 2 years of the date of their accident, or they will be beyond the statute and they won't have any rights. So you're probably thinking, well, okay, I'll keep them for 2 years. There's something else going on here. If somebody is under the age of 18 and the release is signed by their parent or guardian, that person under the age of 18 in California has up to 2 years after they reach majority or the age of 18. In summary, that means they have until they're 20 years old to file the lawsuit. Now, if you're having a kiddie ride or you're having a short ride on one of your events and you've got kids signing up at the age of 10, 11, or 12, that means the 10-year-olds have 10 years to wait until they file a lawsuit. Don't get me wrong, most people don't wait that long. But if you're going to hold these releases, I recommend you hold them for at least 10 years. And as I tell most of the ride directors I talk to, I say hold them forever if you can. You really have nothing to lose because you never know what's going to come back at a later date. Last one, poorly written release. What happens if you get to court, the judge looks at the release and says, wait a minute, the wording in here is improper, this release is not valid, and he or she just throws it right out the window. Well, you don't have a release anymore. So who should write the release? I feel very strongly about this. I believe you should get that release from your insurance company. They are the specialists, in my opinion, in releases. They know what protects them, and they should be the ones writing the release. You should not necessarily go down to a local general practitioner type attorney who will review this for you. I truly believe the insurance company should write them because worst case scenario, let's say the release is stricken. The judge says, no, I'm throwing it out. Well, I think at that point the insurance company still has to defend you. Once again, you see I'm shifting risk. I'm making sure that you are covered and protected. I know, Marla, it doesn't sound great. I know I'm going to get some feedback on this, but I just wanted to make that point as carefully as I could.
Yeah,
so let's move on to the next. What, Marla, are we there?
I was going to say that for the League's insurance program, there is a recommended waiver and release of liability form, and there is another version of it that is geared specifically toward minors. We agree with what you're saying from a perspective of minors. They're not as valuable, but we still like to have a parental release so that we can use that as a arsenal in the defense to help defend the club, even if it doesn't get the case thrown out necessarily. So those are available. I think one of the common things that we see that we highly, highly recommend against is that because people are trying to just get one signature and kind of get everything done with one process, sometimes the waiver language is inserted into a registration form, and it's really important that the waiver itself is signed as is so that someone can't say, well, I was signing it because I was registering for the event, not that because I was agreeing to release the club of any liability. That's a common thing we see, that people are trying to combine everything together, and we don't recommend that.
I think that's a very good point. I think that kind of blends into topic number one here on release exceptions about inconspicuous. It's kind of buried in there. Or maybe they have an excuse that, well, I was just registering and I didn't realize I was necessarily signing a release. So I think that's a very good point, Marla. Well taken. Okay, let's move on here a little bit, and I call this the I'm sorry. Go ahead, Scott.
Yeah, just to jump in a little bit about releases and related topics. So what about somebody who has a ride that crosses state boundaries? You're riding in more than one state. How do you handle the release, for one thing? And are there any other ways that you ought to approach your liability in a situation where you're crossing into different states?
I think in regard to the release, I'm going to let Marla answer that question because we discussed this previously. In regard to the second part of the question, how do you manage your risk when you get into a second jurisdiction and you don't know the law? I suggest that you consult with your insurance company to make sure your risks are covered in each state. If there's any question as to whether or not you're into a new legal system, so to speak, in another state, and some have them, like no fault versus negligence law. You want to make sure your insurance covers you for all of those types of systems. And ultimately, you may want to talk with a local specialist in that other state about what you might want to look for in insurance. But Marla, would you mind answering the question about the release and the specifics on each state law?
Right. Well, I can say with respect to the release and waiver form that the league recommends, or that American Specialty recommends on behalf of the league insurance program, it has been written with the intent to work in as many jurisdictions as possible. So it's been written broadly with the various state laws in mind so that we can have kind of a one-size-fits-all approach. And Gary and I, we may have a little bit of a different philosophy on this because we usually recommend that a club have a lawyer in, if there's someone on the board or someone that they have access to, review it with respect to the specific state guidelines in mind, just to see if there's anything they might add. But it is written with the intent to be as broad as possible for all of the different jurisdictions. So I think it would be a safe approach to just utilize that form, whatever state you're in and whether you're crossing state boundaries, with the idea that, as Gary said, the insurance company wants the release to work, probably even more than you do. And so it is written with the intent to try to have a case be able to be thrown out, basically, at the outset, if possible, based on the waiver.
Okay, a couple of more questions on the registration and the liability. When you do have youth events or youth participating in events, you have a parent signing a waiver for their minor child. How does that help with liability questions?
So I guess the question is, if you have an event for a minor and a parent signs the release for the minor, does the release protect the organization? If that's the question, the answer is yes. It must be signed by the parent, and that would be just as valid as a release signed by an adult.
Okay.
I hope that answered the question. I'm not sure if it did.
I believe so. I will forward the follow-up to you if we get it.
One thing, I know sometimes we have questions. I can't remember if it's New York or New Jersey. I know there are certain states that have regulations against minors signing waivers or against parents being able to waive the rights of minors. And as long as you aren't doing anything against public policy, it's still our recommendation, for the reason Gary said, that it can provide some protection and some defenses to have it signed, because even though maybe the case is still going to have to go on and be tried, you can still show that the parent signed this and that they were aware that there were risks associated, and so it can provide some protection, and it can't hurt your defense. It can only help it, and that's why we recommend that you still make the effort to get those minor waivers signed.
And then once again, let me just reemphasize that I'm really giving you California law, and I'm giving you general guidelines under California law. And what Marla is saying is absolutely correct. I have heard of these cases in other jurisdictions where parents cannot sign a waiver for their child, and it would not be effective. So please check with local counsel if there's any question about that.
Okay. We've got a club here that helps in bike rodeos, so this is a bit of a different topic, and if you want to save this until later, but Rotary clubs are, for instance, holding bike rodeos for kids, and they're not getting any waivers at all. Nothing is signed. Any comments on the risk in that situation?
If I were advising the organization, I would first of all tell them to get good insurance, and secondly, I would tell them to use releases. Absolutely.
Okay, and
I would also say that, Scott, because you referenced the Rotary, if the Rotary Club is really putting on the event, but the League Club has some role in it, we usually recommend that there's an agreement between the two entities so everyone knows who's responsible for what.
And Marla, I think that's a good suggestion, but let me go one step further if I could. In the event from a legal standpoint, in the event a lawsuit comes down the pipe, I can assure you everybody on that defendant list that I talked about earlier is going to get named in the lawsuit. So even though they have a side agreement for perhaps reimbursement or indemnification or subrogation, it certainly is going to be something that might help you out a little bit, but it's not going to prevent that lawsuit from coming down the pipe.
Right. Yep.
and then someone was just asking follow-up on terms of online registration, where someone is checking a box as a liability waiver, typically tied to a payment. So there is some verification. I know that Marla in the past has indicated, I guess, that there's not much case law in regarding online waivers. What are your sort of further thoughts on online waivers, Gary?
Well, as I said earlier, I know there are procedures in place that allow for electronic or online signatures. I mean, we do it every day in internet commerce. You buy things on the internet, or you sign up for a new application or a new program, and yes, I've read all the terms and everything, and I've checked the box. I don't recommend that. I recommend having an original signature, because again, if I have to stand up in a courtroom and I have to show somebody a release if they deny signing that release, I want their signature. I want to be as careful as I can for my client. And so I'm not saying don't do it. I'm just saying from my point of view, if I'm advising a client, I advise them to get original signatures. Marla, I'm not sure if you have anything to add on that.
I'm in agreement. I think the second step in that is if the club absolutely isn't going to do that, and they are going the route of the electronic registration, the electronic waiver, then we say, well, if you are going to take that step, then the best case scenario would be if you tie it to some type of a financial transaction or some way that you are better positioned to say that, yes, in fact, we know that this person is the person who agreed to release the club from liability. So we agree on the fact that it's not ideal, and to get an actual signature is the best practice. But if you aren't going to get the best practice, if you aren't going to take that approach, then we think that's the next best. And I guess I should also mention, and in no way to say that you shouldn't be focused on waivers, because we're absolutely in agreement with the fact that those are valuable defense tools, but the League's insurance program is not contingent upon having and producing an actual signed waiver at the time of the loss. So while we certainly work hard to get it, and the club is happy when they're able to produce it because it can save a lot of time and a lot of money, in the event that you can't find it for some reason, or that it wasn't a valid signature, that doesn't compromise your insurance coverage, which I think is very important for the club.
And let me just jump in. I agree with Marla that, yes, try to get that release every time. But I want you to know also that, and I'm not selling the club's insurance, obviously, but that is a very generous position by her insurance company. I've talked to other insurance companies, and some of them are very strict. No release, no coverage. A lost release, well, maybe you had a plan in place to get the release, but you kind of missed it. Well, we're going to give you coverage, but we're going to reduce the coverage, or we're going to increase your deductible. So Marla's carrier is very generous and very admirable. I have to compliment your company on that, Marla.
Thank you. I appreciate that. And I think also to the credit of the League, because they hold our feet to the fire to make sure the clubs have that coverage, through their endorsed program.
So I think if we move on from waivers here for a moment, and I think there'll be a little time at the end if we need to come back to it, but maybe as a lead-in to this next slide here, I have a couple of questions which I can probably summarize as, oh crap, I'm a director or officer of an organization, we hold bike rides, and how can I protect myself? What am I liable for? How much money are we talking about? Can I really afford to keep giving my time to an organization like this? So you do have people a little shaken here, Gary, but it's time for the good news, isn't it?
It is time for the good news. And first of all, and before I get to the slide, I want to talk about directors and officers. I mean, I have sat on 3 boards over the last 10 years. And one of my requirements is that board has directors and officers insurance. If you are going to sit on a board, you make sure they do. If there's any doubt in your mind whether they do or they don't, do not sit on the board. So it's something you can certainly insure yourself against. And Marla, I'm not sure if the league's program has that kind of coverage, but do you have a brief comment on this in terms of that kind of coverage?
Yes, the league program does have directors and officers liability coverage available. It's something that is purchased separately from the general liability coverage, but it's through a group program, but each club has its own separate limits, and it's very affordable because of the way we're able to deliver that coverage. You can purchase a $1 million or a $2 million limit, and so we absolutely agree that that's something that the boards, that it should definitely be taken to the board of directors at the very least to make a conscious decision of whether or not to buy it. We know that of the 600 clubs that buy insurance through the league's insurance program, only about 100 of them currently buy the directors and officers coverage.
I would encourage everybody to have that kind of coverage. It's my own personal preference when I sit on a board, and I would encourage everybody to do that. Okay, let's move on to the ultimate defense. Now we finally get some really good news. You can insure against almost all of these risks. Really, the only thing you really can't insure against is that ride director from New Jersey shoving somebody. But that is so rare. But I brought it up so you would see that really 99.9% of your risks can be covered. But the 3 best things about insurance are, number 1, the insurance company is going to write your release. Number 2, if a claim comes in the door, they are going to have a claims adjuster on this case immediately. They're going to hire an investigator to do a full investigation. They are going to hire attorneys for you in the event you get sued in a superior court, for example, here in California. They are going to pay for your court costs. They are going to pay for that expert witness to get on the stand and say, I'm a ride director from another jurisdiction, and I can tell you what the standard of care is. They're going to pay for all of this. And number 3, probably the best part of insurance is, in the event you're unable to win your case or it has to be settled, they're going to pay for it. They're going to pay for it up to the limits of your coverage. So even though I've been going over a lot of very difficult concepts and uncomfortable concepts here, I want you to know that hopefully in the last 2 minutes I've given you some great reassurance, because insurance is really your best defense. But now, wait a minute, types of coverage. I'm not going to go into that tonight because I think Marla did a presentation on the league's coverages, and I think that's better covered either by her later or maybe her referring you to that particular webinar. But the real issue here is, have you forgotten anything? I mean, what kind of coverages do you need? All sorts of interesting things when it comes around to a ride event. You cannot head down to your local Allstate or State Farm agent and say, look, I'm putting on a bike ride, can you write me some coverage? They just won't know all the ins and outs. They will not know the foreseeable risks that you're going to have. In fact, insurance agents will tell you about risks you probably didn't even know you had. And they will be able to write you appropriate insurance, which once again, you're going to the expert. You're not going to try to do something for which you don't have the skill set. So please go to a specialist like Marla or somebody else who knows all about these types of events. How much insurance do you need? Well, a lot of the time, if you get a permit from a government or another agency, they're going to tell you how much insurance you need. I'll keep it pretty simple. In regard to the liability part of your policy, that's the part that where those 7 elements of damage and expense will come out of. Well, actually, liability plus property damage. On the liability part, I say you need at least $1 million. I know that sounds like a lot, but in today's world, even though most of these claims don't even get close to $1 million, you know, you never know. It's always good to have more insurance, and as Marla will tell you, the higher the limits go, the less you pay for the increments. And the reason is, and Marla, correct me if I'm wrong, the less probability that you're going to get into those higher limits. So please, I would say about $1 million of insurance is a good way to let you rest easy after the event. Okay, now let's move on. Oh, a claim. Oh, now what are we going to do? You know, I mean, I was careful as I could have been. I drove the route. I didn't look down at my smartphone. I noted everything. I got my permits. I put my signs up right. I have crowd control. And then all of a sudden, here it comes. Let me start off by saying what you should not do. Don't start running around getting witness statements. Don't start running around taking pictures of the scene. Don't start if you happen to be at the scene, don't start moving the vehicles around, the bikes and the cars or anything else. And the last thing you want to do is get on the internet and start tweeting or sending emails to everybody. Trust me, you're not the expert in investigating an accident. The police are. Get the police out there, get the first responders, the paramedics, but the phone call you really should make after that is to your insurance company, because really one call does it all. I know it's a silly saying, but it really does. You call them, you tell them, look, I know a claim is coming in. I remember, you know, this guy's on the ground, he hit that pothole that we didn't see, and his arm was gushing blood, and I tried to help him, but he was laying there on the ground saying, I'm going to sue you guys for this, and you know a claim is coming your way, or you get a written demand for a claim. You have to just call your insurance adjuster, and they will take care of everything. And they'll hire the investigators, like I indicated, and do the investigation, communicate with the injured party. They will ask you for information when it is appropriate. But please, don't become the insurance claims adjuster or agent. Don't become the lawyer. Don't become the investigator. Just call your insurance agent or claims person if you feel a claim is coming in the door. So let's move on. Finally getting to the end here, then we'll do some more questions, and maybe Marla has a few points she wants to make. In regard to negligence, be careful, not careless. Just use your good common sense. You don't have to be perfect. You don't have to get an A+ standard on this. Believe me, B or B+ is perfectly fine. Remember, don't assume a task beyond your skill level. And we talked about numerous ones. Fixing a road, so to speak, putting carpeting on a cattle grate, directing traffic, safety checking bikes, selecting your appropriate insurance coverage. Don't do things that you simply don't have the expertise for. Next, always use written releases written by your insurance company, and from my point of view, get original signatures. Next, purchase insurance from a specialist like Marla. And finally, look, we've been talking about risks all night, and I want to thank all of you who have stayed on the line and put up with me telling you how scary all of this is. But remember what you're really doing. You are promoting bicycling. You're making your communities better places. If you're putting on an event, raising funds for a charity, you are really doing something for the greater good. Please never lose sight of who you are and what you do, and insure against those risks and go forward and put these events on. Thank you very much for having me on this evening. I'm happy to stick around for questions. So Scott, I'll turn it back to you.
Well, I think now we talked about giving Marla a chance to talk a little bit more about the League's insurance policy with American Specialty, and then I'll follow up with what questions we have time for.
Absolutely. Scott, are we looking at trying to wrap up in like the next 10 minutes?
I think we should, yes. I would like to try to wrap it up in the next 10 minutes.
I think the main point to make, first of all, thank you to Gary, because everything he mentioned is so helpful. It's very important to understand the types of things that clubs can do to prevent lawsuits, to make yourself more defensible when they do happen. But as he said, the good news is that you can buy insurance coverage to protect against the types of losses that we've been talking about for the last hour. And I think the even better news is that the league provides an insurance policy. When Gary talked about working with a specialist, I appreciate him recognizing American Specialty as being in that role. All we do as an agency is provide insurance and risk management services for sports and entertainment organizations. So I would put us in that specialist category. And the league has come to us and worked with us for very many years. And as I said before, holds our feet to the fire to make sure we're putting together a program that's specifically designed for bicycle clubs. And every year we get together and we talk to clubs and we revisit areas where we might want to broaden the coverage, where we might want to clarify what coverage applies, because we have observed that clubs are getting into more and more activities. It's not necessarily just the traditional club ride and then maybe a fundraising special event, that more clubs are becoming involved in bicycle education and those type of things. So we've tried to ensure that the program keeps up with that. The program does provide general liability coverage with $1 million limit. Gary talked about that being kind of the minimum you want to look for. The defense coverage to pay the costs associated with defending the club are actually unlimited, which is great news, because that a lot of times is where a lot of the expenses come into play. And another key point I want to make quickly is that you are also able to purchase an additional $1 million, so that you would have a $2 million limit, which some of the venues, some of the governmental agencies are requiring. But you should definitely contact us to get a quote, because we're able to, in some cases, provide that coverage for only $50 for an additional $1 million. It's going to depend on your club-specific activities, but it's very affordable. The program will automatically also, when you enroll in it, provide participant accident coverage, which we didn't talk about that because we're focusing more on situations of liability. But just so you're aware, that coverage applies and pays for medical expenses to an injured participant. It applies after their own health insurance pays, but it can actually pay for their health insurance deductibles and co-pays. And that's a great tool that we find can help prevent someone from suing you. So the idea being, they got in an accident, maybe they've incurred some medical bills, but instead of looking to the league or to your club to pay for those medical bills, they already have that coverage available through this, what we call participant accident coverage. The other key point I would say is to talk to your board and definitely consider buying the directors and officers liability coverage. I agree that that's a very important coverage to have in today's world. The board of directors is covered under the general liability policy, but the directors and officers coverage applies to different types of claims that might not be covered under the general liability. So the two coverages dovetail. And if you don't have both, you're kind of missing one of the core tenets. So definitely look into that. And then there's also non-owned and hired auto coverage that's available on an optional basis. So to the extent that you have people driving on behalf of the club, that provides the club with coverage that isn't provided under the general liability policy, because that policy, the general liability policy doesn't cover lawsuits that are arising out of the use of a vehicle, and that auto coverage I just talked about does. And all of this information is available on the league's or on our website, which is www.amerspec.com/LAB. That's where you can get information about the insurance program and also enroll in the insurance program. We really expanded the FAQs this year and tried to provide more information, and the enrollment process was changed this year too, so that it will key you in on really how the coverage works and kind of alert you to certain areas of optional coverages that you might want to consider. So that is a very quick overview. And Scott, maybe you could let people know if they wanted to actually hear the insurance presentation that was last month, where they should find that.
Right. All of our previous webinars are recorded and archived under the Club Corner on the website. It's one of the items under the members menu on any page of our website. You can find the club group corner and then go to the club leadership training page, and you can find that and review that. Someone pointed out that things have been very harmonious so far, but maybe there are ways we can drive a wedge between the two of you. So Gary's advice is not to get statements in the event of accidents, but the American Specialty Event Reform, the event forms that you need to fill out asks for some of these things. Marla, do you want to talk about the claim forms, and would you
Sure.
advise any different than what Gary has suggested in terms of your insurance
I don't
coverage?
think that we don't disagree with Gary's advice. I think it's more a condition. We absolutely want to be contacted, especially in the event of a serious accident. The 800 number we have will actually put you through to a claims person 24 hours a day, 7 days a week, because we know your events often take place most of the time not during business hours, because that's when people are working and not available. So you definitely should call us. We have that form available, though, and would like to have it completed so that we at least have the names of people who might be witnesses, because depending on the severity, it might not be something where the claims, where we're able to send someone out right away. And so to the extent you're able to at least identify who the people are who were there and take a couple pictures of something that we might not be able to have otherwise, we do recommend doing that. And I think the key is to utilize that form as a way to walk through it, because I definitely agree with Gary. You don't want to go overboard because you could end up creating more problems for yourself. So that form will hopefully guide you through kind of a quick process for gathering pertinent key information up front.
And Scott, I would probably agree with that. When I mentioned that I wouldn't recommend getting statements from people at the scene, witness statements, at least in my experience, you get one bite at the apple when you call a witness, and because they just don't want to get involved in the first place usually. And you want to have a private investigator or somebody or an adjuster get that statement in a certain format and properly recorded. The reason is, in the event you have to use that statement in a courtroom, if the person who gave the statement denies something in that statement, you need to put that insurance investigator or adjuster on the witness stand and authenticate the statement. So how the statement is taken is just about as important as the content of the statement. So that's really what I was getting at.
Okay, good. Thank you for the clarification. One quick question. Somebody's just not clear on what directors and officers coverage offers beyond what the liability does. You mentioned there are a few extra things it covers. Marla, could you tell us more about that really quickly?
Sure. I think to me the biggest area for a nonprofit club would be a discrimination type claim. If you for some reason had to remove a member from your organization, maybe because you just feel that they're not following your safety guidelines or your protocols, and you remove them and they allege that you discriminated against them and they sue the board or they sue the club, that same type of claim could occur for those clubs who have employees. If you have to terminate somebody, those type of claims would be covered under the employment practices part of the directors and officers coverage, and none of that is covered under the general liability policy. That is kind of what we've always referred to as like the core league program coverage. The other one would be if the club, if the directors and officers are accused of misappropriating, not necessarily a theft type of a situation, but just that you unwisely use the funds of the club or that type of a wrongful act, that type of an allegation could be picked up. I haven't actually seen a claim like that occur, although it's an example we often give. But I think the discrimination piece is the one that's more likely for a nonprofit sports organization.
Okay, I do have a few more questions that we're not going to get to. There is one last question that I want to ask. This presentation has been very much about special event rides and one-time events. Most everybody here in the presentation probably does that sort of ride, but most everybody here also does regular club rides. They're riding every day of the week in some cases, different rides. And just can we broaden the idea of ordinary care so that people understand how to manage their liability in a day-to-day rides type of situation?
Scott, let me jump in here. I must say that I normally don't advise a club in this situation as opposed to a ride director or a club putting on a specific event. However, I will say, as a general rule, the same principles apply to your daily club ride. If there is a known danger out there that perhaps riders won't know about, I think if you can, you need to warn them about that. I think also that you don't have to go out every day before the ride and do the course. But if there is something going on, I know some clubs that I belong to, they get alerts from the local government saying there is going to be a detour on this road for the next, or a lane closure on this road for the next month. And the roadway and the bike lane is going to be taken away, and the roadway is going to be narrow. Well, the bike club at that point, I think very generously sends out a warning to everybody saying, look, this is going on, and we just want you to be aware of this. We are changing the ride from this route to another route. So again, if you know something is coming up, if you've perhaps been advised that you're going to be in a really narrow lane situation, you may want to take steps to be careful and reasonable and change the route. And that's the way I see it normally happening with club rides. Marla, do you have anything to add to that?
No, I think that makes sense. Absolutely. I think you do have to probably adjust your standard of care. Might be a little different if it's people that are used to riding with you, but I agree you still have to take those standard precautions and try to warn people of something that a reasonable person would warn them of. So I do, with the league program, I would say that most of our claims do come out of the special events that are more geared toward being open to the public, and some of that may be because your own members may be less likely to sue you. Again, you can't hang your hat on that, or you can't count on that goodwill, but I do think that if we look at the history of the league program claims, it kind of bears out the idea that your highest alert needs to be in the special event if you're talking about potential lawsuits.
Okay, thank you very much. Gary, do you want to give out any contact information? Can people follow up with you if they have further questions on your presentation?
If they have any questions, they can go to my website, which is Bicycle Lawyer, all one word, bicyclelawyer.com, or they can email me at gary@bicyclelawyer.com.
And Marla, how do people get in touch with American Specialty Insurance?
For American Specialty, they can call our 800 number, which is 800-245-2744, and they would want to either ask for myself or Renee Watterson. Renee is who they would likely get directed to because she answers most of the inquiries from clubs. And I guess I see that you posted my email, but it's mPeters@amerspec.com, or Renee's is R Watterson, WATERSON, @amerspec.com.
Okay, thanks.
Yep, those would work.
Awesome. Thank you, Marla Peters, Senior Vice President in charge of special programs with American Specialty, who provide the insurance for clubs that the league offers. Marla's been working with us 17 years. Thank you. Gary Bruston, Bicycle Lawyer, League of American Bicyclists Board member. Thank you very much. I'm Scott Williams, Membership Director of the League of American Bicyclists. Thanking everybody who joined us tonight. I hope you found it informative. Please follow up if you still have questions. A lot of you did. I'm sorry we couldn't get to all of them. but hope it was helpful. My email is Scott, S-C-O-T-T, @bikeleague.org. My number is 202-621-5453. Follow up with us. We will try to help out. And thank you, everyone, and have a great night.